If you're not familiar with Reg BI, something you need to do fairly quickly because it's fairly complex. There's a lot to it. There's a lot of nuances to the disclosures and all the other things you need to do, so you should probably get working on it fairly quickly. It is going to be a challenge and it is fairly complex. So under the 4 obligations of Reg BI, the first one is the disclosure obligation. The disclosure obligation requires you to sort of define the relationship you have with your clients, how that works, what you're going to be doing for them, what their expectations should be or can be, what you intend to do, and how you manage the relationship. It also is going to require you to include disclosure about all the fees and costs that your clients are going to pay. Oyster can help you with defining that relationship and putting in the appropriate language. Oyster can also help you figure out how to explain all the fees and costs and do it in a fairly concise but easy to understand manner. The other obligation or big part of the disclosure obligation is what is called Form CRS, and that is either a 2-page or 4-page document as required by the rule, depending on whether or not you are just a broker-dealer or a dual registrant. Oyster can help you create and put the appropriate disclosure in Form CRS to meet this obligation. The second obligation under Reg BI is the care obligation. And what that really is suggesting or telling you need to do is you need to review and enhance your policies and procedures to incorporate the requirements of Reg BI. So your WSPs, or your written supervisory procedures, need to include specific areas to deal with the requirements of Reg BI. That goes into a number of different areas, including product offering, for example, identifying strategies, things of that nature. But the other thing that is a challenge with the care obligation is making sure that you are appropriately evaluating what is called the reasonably available alternatives, meaning other investments, other products that may fit your client's needs, but you need to make sure that they're in the best interest of the client, and you need to be able to evaluate and document that. Oyster can help you with all of these requirements because we have the experience to work with policies and procedures. We've dealt with products. We've got folks that have done this for years, can help identify strategies, and clearly probably the more complex is evaluating the reasonably available alternatives and making sure that you document the reasonably available alternatives that are in your client's best interest. The next obligation under Reg BI is the conflict of interest obligation, perhaps the more challenging and most complicated of all. The conflict of interest obligation requires the firm to disclose all conflicts of interest. You either have to disclose the conflict of interest, mitigate the conflict of interest, or eliminate it. I think this is perhaps one of the most challenging aspects of the obligations and under the regulation, because the more you delve into how many conflicts you potentially have or the firm potentially has with all sorts of different providers, vendors, and things like that, product folks, I think it gets fairly complicated. Oyster has developed a fairly complete matrix to help you identify all of the conflicts that maybe are confronting your firm, which I think is probably one of the more challenging aspects, and then figuring out what's the best avenue, either whether it's something that can be eliminated without causing firm harm or causing harm to your clients, whether it can be mitigated, or if it's just one of those things that needs to be disclosed and how to disclose it properly. So identifying all the conflicts of interest is perhaps one of the more challenging aspects of the rule. I think the matrix that we have developed can be very helpful in that. The other thing that needs to be done under the conflict of interest obligation is you need to develop enhanced surveillance procedures to ensure that you are in fact making sure as the firm moves on that it continues to identify all of the new and incoming conflicts of interest. As the firm grows, takes on different providers, different vendors, different products, all of those need to be incorporated in your conflicts of interest disclosure, or it has to either be mitigated or eliminated, as I said. The last obligation under Reg BI is the compliance obligation, and what that requires is that the firm have policies and procedures in place to ensure that they are complying with the requirements of Reg BI. This is probably not the more complicated one, but it's something that you need to do, and you need to make sure, as we know, you're not required to have a perfect system of compliance. You're supposed to have a reasonable system of compliance. But what you need to do is make sure under Reg BI that you have a compliance system in place to make sure that your firm is meeting all of the obligations under Reg BI and doing it appropriately. Oyster can help you do that based on our experience and knowledge with dealing with compliance and regulatory consulting, as we've done for the last 11 years.